This has to do with the rather controversial case of Roe against Wade. That case landed on my desk early in my years here. I came on board in June 1970, and Roe against Wade was decided in January 1973.
I believe most people would associate Justice Blackmun with the fact that he wrote the majority opinion in Roe versus Wade. When the Supreme Court decided Roe, he was in the majority, and there were actually 7 justices who decided Roe, and there were only 2 dissents. At a later time in his life, when the court seemed to shift a little bit in its reasoning as to what the extent of the constitutional right to an abortion was, Justice Blackmun became a very forceful advocate for his original position. But when he retired from the Supreme Court, Roe was still good law, and I guess by most people's reckoning, it still stands today, even though there have been a number of cases that have sort of chipped away, perhaps, at the expansive rights that Justice Blackmun thought existed. Justice Blackmun's ties to Minnesota are that he was a native son. He was born in St. Paul. He was educated in St. Paul. He went to college at Harvard, graduated from the Harvard Law School, and returned to Minnesota to work for a federal circuit court judge as his first job out of law school. He later then was hired by a prominent Minneapolis law firm where he was a partner for roughly 10 years, and then came to Rochester to be the resident counsel of the Mayo Foundation or Mayo Clinic. And he operated in that role in Rochester here for about 10 or 11 years, when he was then nominated by President Eisenhower to be a judge on the 8th Circuit Court of Appeals, the area of which included Minnesota and several other surrounding states. Circuit judges do not have to live in a particular place except within the geographic area where they serve. So when Justice Blackmun was nominated to be a circuit judge, he was able to remain in Rochester. He had his offices in Rochester. He would travel periodically to hear arguments at other places like St. Paul, St. Louis, and perhaps Little Rock, places like that within that area. But he lived his life pretty much for the next 10 years as a federal judge in town here, and then was nominated in 1970 by President Nixon to be on the United States Supreme Court. He served in that capacity from 1970 to 1994 when he retired. He was a very dedicated individual in terms of his craft. I recall reading somewhere that he replaced the man on the 8th Circuit, I think Judge Sanborn, who he had worked for originally out of law school as a clerk 20 years earlier. And when Judge Sanborn retired, Judge Sanborn, I believe, had his chambers up in St. Paul. And I think I recall a story that Justice Blackmun actually asked to have Judge Sanborn's desk sent down to his office here. And Judge Sanborn was kind of the old school type person in terms of things. He would stand at this desk and write standing up, which was the practice perhaps 100 years ago from people. And I guess Justice Blackmun liked to also write some of his stuff out in longhand that way. Nowadays, those of us who practice law have computers and things like that that pretty well replicate things almost instantaneously. But that was the style that Justice Blackmun apparently had, and he was very, very particular about his opinions, from what I am told. He was also a man who kept everything. So I have read recently that his archive in the Library of Congress is the largest single judicial archive that the Library of Congress has in terms of its sheer volume. It's except for that of Justice William O. Douglas, who served a longer time than Justice Blackmun. But so he was a man who was very meticulous, kept everything, kept good records, was very careful about the way he wrote things, and it shows, I think, when you read his opinions. The case was argued the term prior to its release. In other words, it was one of those rare cases, apparently, where the Supreme Court, after hearing the original argument, decided at the end of their term, and the Supreme Court terms end usually in June or May or June of a year. If a case isn't decided by then, sometimes it's carried over to the next term of court and re-argued. And that was what happened in Roe. During that summer, Justice Blackmun actually came back to Rochester to visit. He spent some time in the library of the Mayo Clinic doing some research on issues that interested him in terms of fetal viability and things of that sort. And he perhaps may have talked to folks in the Rochester community who were physicians who had some knowledge of these things. I don't know if Harry Blackmun was ever considered to be a person with a lot of medical knowledge, but certainly working for the clinic for the number of years he did and living in the community as a circuit court judge, he would have been exposed to an awful lot of information. And there is some story that claims that he came back and actually spent some period of time researching some medical issues that bothered him or were on his mind prior to the case being re-argued the second time. The principal argument in Roe is whether or not there is some form of a constitutional right that a person has that basically forbids the government from interfering with a decision by that individual to terminate a pregnancy. In the original Roe decision, the majority of the court at that time basically decided that there was a constitutional right to privacy, which basically forbade the state from regulating a person's decision in some circumstances to terminate a pregnancy. The court in Roe decided that a person who wishes to terminate a pregnancy has a constitutional right based on a right of privacy to make that decision without interference from the government in certain circumstances. And the Roe framework was basically that the state's interest in that was pretty well restricted in the first trimester of the pregnancy, and as the pregnancy advanced, the state's interest in protecting the health of the mother or the health of the fetus justified more and more intrusion or restrictions. But at least in terms of the first early stages of a pregnancy, the court basically decided that the government had very little, if anything, to do with that. That was something that was the decision by the person involved and their treating physician. As years went by, the legal underpinning of that, the so-called constitutional right to privacy, became less important to a majority of the court, such to the point that within 10 or 15 years, Justice Blackmun was complaining that the way the court was deciding these cases involving abortion rights or abortion restrictions or whatever, that they had kind of jettisoned the original underpinning of the decision itself, which was a person's right to privacy. The majority of the court at that time was starting to find that the government had interests that overrode the constitutional rights of the persons who wished to terminate their pregnancy. Basically, the way the decision was written basically called into question the constitutionality of the laws of 46 of the 50 states that regulated pregnancies or abortions or things of that sort. So that there had to be some adjustments made in some cases because a state law might have made it a criminal offense. In some cases because a state law may have forbade a medical provider from providing that service, and et cetera. So it had a great impact in terms of, the laws of a number of states. I think the social impact of Roe versus Wade is probably greater than the so-called legal impact. If you look at, some people will probably look at Roe versus Wade as kind of a watershed moment in terms of this whole issue of whether or not the so-called divide we have in some places between folks who consider themselves to be pro-choice, in quotes, and those who consider themselves to be, in quotes, pro-life. Obviously, at this time in our history, we have a lot of divisive issues that come before the public, but I think if you go back to Roe versus Wade, that may have been the start of that sort of political upheaval. It put people in some cases in two very different sort of camps, and it had really at that point not so much to do with one's politics, but it had a lot to do with one's conscience, I would suspect, in terms of what they felt, what a person felt in terms of that issue. Legally, I think the criticism was, and I think became, the fact that Justice Blackmun's recognition of this right to privacy as a constitutional right in the context of this medical procedure was probably an overextension of the right to privacy. And I think in subsequent decisions, as the court took up issues involving the regulation of this procedure, justices or other judges would basically find fault with Justice Blackmun's expansive view of the right to privacy in the constitutional sense. I think the most recent jurisprudence from the court over the years would suggest that a majority of the judges at this point, or the justices at this point, would not find a right of privacy as expansive as Harry Blackmun did in the Roe decision. I think Justice Blackmun, later on in his life, was not ashamed to tell people that he was not very popular in some places. I attended a couple of programs that Justice Blackmun gave presentations at after his retirement or around that time, and he would sometimes delight in telling the people in the audience, he would read them letters he had gotten from people. And he sort of delighted in reading these letters, and some of these letters were they were awfully nasty. They, in some cases, would have made threats to him that would have been probably a criminal offense in some cases. But Justice Blackmun supposedly read all those letters. In some cases, I don't know what his reaction to them was, but he seemed to be somewhat proud of the fact that some people disagreed with him. This man served on the Supreme Court for almost 20 years, and he would have been involved in hundreds of decisions. He wrote a number of opinions. In some cases, his opinions in his later life were somewhat at odds with his earlier view of certain things. But for better or for worse, he's going to always be remembered for this decision. And I dare say that rarely, at this point, it's hard to remember anyone else who was involved in the writing of Roe versus Wade. I had to go back the other day and remind myself who was on the bench at that time and who dissented from that decision and who were in the majority. And again, it was a decision where 7 justices decided that Roe versus Wade was the right decision, and yet I don't think anybody remembers who else joined in the majority. I think there is, some people might remember that Justice Rehnquist, before he was Chief Justice, but just was a dissenter, and so was Justice Byron White. But the rest of the members of the court were joined in the opinion, and nobody ever tags those folks at this point as being the ones that created the right to have an abortion. It's Justice Blackmun, for better or for worse, basically becomes the historical figure in this case.
Oh, I think any case up here always stands a chance of being overturned. I can't forecast that one way or another. It may well be overruled. That will depend primarily on the personnel of the court, I think. But it has stood for 14 years now. I think it is a landmark decision along the road that we must take toward the emancipation of women.